Hello, everybody, and welcome back to Brian's podcast. My last video was the Constitutional Man with Carl Miller. Guy is amazing with the Constitution, and he will tell you things that the government don't want you to know. So here's part two that I think you need to see.
The next argument there, which is argument number 98, which basically deals with the effect of an emergency. While an emergency cannot create power, and no emergency justifies the violation of any of the provisions of the United States Constitution or state constitutions, public emergencies such as economic depression, for especially liberal construction of constitutional powers. And it has been declared that because of national exigency, it is the policy of the courts in times of national peril so liberally to construe the special powers vested in the chief executive as to sustain and effectuate the purpose thereof, and to that end also more liberally to construe the constituted division and classification of the powers of the coordinate branches of the government, and insofar as may not be clearly inconsistent with the Constitution, right? In other words, it can't be in conflict with the Constitution to vest extraordinary powers in the chief executive. But I'm telling you, on the other hand, a contention that a grave emergency such as the Depression should permit construction of the constitutional provisions which would meet the emergency was rejected. In one case, the court holding that neither the legislature nor any executive or judicial officer may disregard the provisions of the Constitution in cases of an emergency, where the plain and unequivocal terms of the Constitution present to question of construction as to departures in emergencies. So not even an emergency justifies the taking away of constitutional provisions. And I know you've heard differently. I know you think, well, they got an emergency. They just declare an emergency and then the president issues an executive order. But let me ask you, if it's repugnant to the Constitution of the United States, is it law? No. Who says so? We do. We're the people. It's our country. It's our Constitution. We're the ones that say you can't do that. And we mean it. We therefore better listen. All right, now, let's get into the next argument here. Now, I hope I'm not boring you to tears here, but it's kind of important that we cover these basic things so that you can understand. As to the construction with reference to the common law, an important canon of construction is that constitutions must be construed with reference to the common law. That means the law of the little people out there, not the corporations. Okay? Since in most respects the federal and state constitutions did not repudiate but cherished the established common law, this fact has been taken into consideration by the courts in construing certain clauses in a state constitution, such as the provision securing the right to a jury trial. Also, provisions in regard to crimes have been interpreted with reference to the common law rule that one charge for the crime may be convicted of a lesser offense necessarily included in the crime charge. In such cases, the courts of the state always regard the language in the common law sense. So the common law prevails. Don't let anybody tell you this admiralty law prevails, because it only prevails if you get sucked into it. We're not going to let you do that. We're going to teach you how to beat it. The common law also permitted destruction of the abatement of nuisances by summary proceedings. Traffic tickets, folks. That's what a traffic ticket does. It is a writ of assistance, a bill of attainder. It's unlawful in the United States of America. And it was never supposed that a constitutional provision was intended to interfere with this established principle. And although there is no common law of the United States in the sense, who said so? Erie Railroad versus Tompkins. Okay? All right? Of a national customary law, as distinguished from the common law of England, adopted in the several states. In interpreting the federal Constitution, recourse may still be had to the aid of the common law of England. It has been said that without reference to this common law, the language of the federal Constitution could not be understood. So the common law applies, folks. And we're going to get into that common law heavily in the advanced section, all right? Okay. Now let's get back into this. In interpreting the federal Constitution, adopted by the several states, all right, the recourse may still be had to the aid of the common law of England. It has been said that without reference to the common law, the language of the United States Constitution would not be understood. This is due to the fact that this instrument and the plan of government of the United States were founded on the common law as established in England at the time of the Revolution. Okay? Therefore, it is the general rule that the phrases in the Bill of Rights taken from the common law must be construed in reference to the latter. Specifically, the United States Supreme Court has taken the common law into consideration in construing the Fourth Amendment, the Fifth Amendment provisions relating. All right? So the common law is extremely important that we get, and we will cover that thoroughly. It's important to understand that most of you out there aren't citizens at the common law. That only those that understand the differences in admiralty and maritime law, those that are corporations, officers of corporations, or officers of government residing in the District of Columbia, the 14th Amendment duality of citizenship, which is talked about in the case of Erie Railroad versus Tompkins, which is a rather heavy argument. And I will cover that thoroughly with you so that you understand where the traps and the differences are. But for right now, I'm trying to demonstrate to you construction and programming so that you can understand that this Constitution right here is the supreme law of the land. It is a contract in writing. It is enforceable in favor of you. In an open court of law, you are the beneficiary. Okay? I want to give you some basic more points on this Am jurisprudence argument. This is section 114 of the 16th volume of Am jurisprudence second. I'm going to give you a couple more of these sites so that you can understand how powerful a document this is. Okay? By the way, I highly recommend you go down to the law library, grab that 16th volume Am jurisprudence, start at section 1 and start paging through to section 300. You will absolutely be astounded. We are now in 16th Am jurisprudence second, section 117. And I will read it to you. Basically, various facts and circumstances extrinsic to the Constitution are often resorted to by the courts to aid them in determining its meaning. As previously noted, however, such extrinsic aids may not be resorted to where the provision in the question is clear and unambiguous. In such a case, the courts must apply the terms of the Constitution as written, and they are not at liberty to search for meanings beyond the instrument, which that militia argument and that collective law theory of the Second Amendment is. They're reaching far. All right? Clearly it says in the plain English, the right of the people to keep and carry arms shall not be infringed. Now, what is it you don't understand about the word infringed? They're infringing. The Brady Bill, it's infringement. 1968 Gun Control Act, it's infringing. All of these, the CCW acts of these states, they're infringing. Who says so? You do. How shall a document be enforced in favor of who? You. When are you going to enforce it? You're the one that is the citizen. All power is inherent in the people. You're the one with the power. Enforce your power. All right? Does everybody understand that argument? That's the magnificence. I'm bringing the genie out. We're stroking the bottle here. And I'm going to bring the genie out here in a second. You're going to understand the magnificence of the power of this book. You see, once you understand this is an ironclad contract, once you understand that this is enforceable in the court of law pursuant to the statute of frauds, once you understand you have a right to claim specific performance on the contract. Your Honor, I'm demanding my right to keep and carry arms, and that right shall not be infringed. I want specific performance. I am the holder of the contract. It's supposed to be enforced in favor of me. I am the clearly intended and expressly designated beneficiary, the citizen. I want the thing protected in favor of my right. Does that make logical sense to you? Now do you start to understand the power of this document? Okay? See, before, you just thought it was a bunch of writing in some textbook that you had to take when you took a civics class in high school in the 11th grade. See, I want you to understand that you don't leave home without this. This is more important than your credit card. Okay? Next, let's get into the next section. I'm going to cover some more of these Am jurisprudence sections so that you can understand. I want to get into section 155. 16th Am jurisprudence second, section 155. Since the Constitution is intended for the observance of the judiciary as well as other departments of government, and the judges are sworn to support its provisions. God means sworn, as an oath of office, sworn. The courts are not at liberty to overlook or disregard its commands or countenance evasions thereof. It is their duty in authorized proceedings to give full effect to the existing Constitution and to obey all constitutional provisions, irrespective of their opinion as to the wisdom or the desirability of such provisions, and irrespective of the consequences. Thus it is said that the courts should be and are alert to enforce the provisions of the United States Constitution and guard against their infringement by legislative fiat or otherwise. In accordance with these basic principles, the rule is fixed that the duty in the proper case to declare a law unconstitutional cannot be declined and must be performed in accordance with the deliberate judgment of the tribunal before which the validity of the enactment is directly drawn into question. If the Constitution prescribes one rule and the statute another, and a different rule, it is the duty of the courts to declare that the Constitution and not the statute governs in cases before them for judgment. Does everybody understand that? They're telling the judge, you got to rule in favor of the Constitution. And if you know your Constitution, whose favor are they going to rule in? Yours. But you have to have enough hair on your tail feather to walk in there and say, hey, I'm an American, and I have a constitutional right. That right shall not be infringed, and you're infringing. And I'm asking you not to do that, because it's not nice. And I'm asking the judge to do his duty under his sworn oath of office and uphold the United States Constitution as he swore he would under Article 11, Paragraph 1 in this state, which says that he shall swear to protect and defend the Constitution from all enemies, foreign and domestic, and he will perform his duties to the best of his ability, so help him God. Now, let's get closer to so help him God. Now, let's get into another one of these. We got a load of them, folks, so let's bear with me here. 16th Am Jurisprudence, 2nd, Section 177. Declaratory judgments. Declaratory judgment actions have often been utilized to test the constitutionality of a statute and government practices. The Uniform Declaratory Judgments Act makes specific provisions of the determination of construction or validity of statutes and municipal ordinance by declaratory judgment, and is considered to furnish a particularly appropriate method for the determination of controversies relative to the construction and validity of the statutes and of ordinances. The Federal Declaratory Judgment Act, although it does not mention declarations as to the construction or validity of the statutes, has been invoked frequently as a means of assaying the constitutionality of congressional legislation. A plaintiff can have a declaratory judgment action on the constitutionality of either the federal or state statute by a single federal judge, so long as he does not ask to have the operation of the statute enjoined. You can't enjoin a constitutional right. A court may grant declaratory relief unless there is a case of controversy before the court. That is, the dispute must consist of specific adverse claims based upon present rather than future or speculative facts on which to base the adjudication. All right? I'm trying to tell you folks here, you have a right to demand a declaratory judgment, which we are going to do in several of our cases here. And they got to declare, is it constitutional or isn't it constitutional? If it's constitutional, it has to be judged in favor of who? You, the citizen. Why? Because you're the beneficiary. It's supposed to be enforced in favor of you, the beneficiary, the citizen, for the protection of rights and property. See Byers v. United States, 273 U.S. 28. And the 40 Supreme Court cases that support that mandate. Okay? Now there's just a couple more here. Bear with me. I know you're probably bored to tears right now, but I don't want you to do that. I want you to pay attention. Okay, we're at Section 255. 16th Am Jurisprudence, Section 255. In all instances where the court exercises its power to invalidate legislation on constitutional grounds, the conflict of the statute with the Constitution must be irreconcilable. The Brady Bill. Irreconcilable. Huh? In other words, the court is without authority to declare a statute unconstitutional unless it is in positive or direct conflict with the statute or with the Constitution. Thus, a statute is not to be declared unconstitutional unless so inconsistent with the Constitution that it cannot be enforced without a violation thereof. Because that would be violating the Constitution. We can't have that. What happened in Marbury versus Madison, 5 U.S. 137, same thing. A clear incompatibility between law and the Constitution must exist before the judiciary is justified in holding the law unconstitutional. This principle is, of course, in line with the rule that doubts as to constitutionality should be resolved in favor of the constitutionality. and the beneficiary, you, the citizen, for the protection of your rights and property. Okay? Does everybody pick up on that? Now, let's shift to 256. 256, right here. The general rule is that an unconstitutional statute, whether federal or state, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of the enactment and not merely from the date of the decision so branding it. Wouldn't it be interesting if 34, where's 34? There's 35, all right, here's 34. State ex rel versus Nguyen v. Greer. But I'll tell you what, Marbury versus Madison comes higher than that, okay? All right, 34, let's cover that again. And ineffective for any purpose, since the unconstitutionality dates from the time of the enactment and not merely from the date of the decision so branding it. An unconstitutional law in legal contemplation is as inoperative as if it never had been passed. The Brady Bill, the Crime Bill, the 1968 Gun Control Bill, all these bills. Such a statute leaves the question that it purports to settle just as it would be had the statute not ever been enacted. No repeal of an enactment is necessary. Since an unconstitutional law is void, the general principle is follows that it imposes no duties, confers no rights, creates no office, bestows no power or authority on anyone, affords no protection, and justifies no acts performed under it. A contract, did everybody pick up on that keyword, contract? A contract which rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. Persons convicted and fined under a statute subsequently held unconstitutional may recover the fines paid. A void act cannot be legally inconsistent with a valid one, and an unconstitutional law cannot operate to supersede an existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land, the Constitution, it is superseded thereby. Since an unconstitutional statute cannot repeal or in any way affect an existing one, if a repealing statute is unconstitutional, the statute which it attempts to repeal remains in full force and effect. And where what did I say there? Remains in full force and effect. Is the Second Amendment in full force and effect? You better believe it. Okay? Now what is it they don't understand about infringe? And where a statute which it attempts to repeal remains in full force and effect, and where a clause repealing a prior law is inserted in the act, which act is unconstitutional and void, the provision of the repeal of the prior law will usually fall with it, and will not be permitted to operate as repealing such prior law. In other words, the law stands always, the real law, the Constitution. The general principles stated above apply to the constitutions as well as to the laws of several states insofar as they are repugnant to the Constitution and the laws of the United States. And let's see if 54 will confer. Kuhn versus Berry, but I can tell you Marbury versus Madison is higher than that, but I'd be willing to bet they cited Marbury in that. Moreover, a constitution of a statute, a construction of a statute which brings in conflict with a constitution will nullify it as effectively as if it had, in its express terms, been enacted in conflict therewith. So, anything passed in conflict with the United States Constitution is clearly unconstitutional. It doesn't take a college professor graduating magna cum laude from Harvard to figure these things out. All you have to do is read. That's why God gave you eyes now. The actual existence. Well, let's go to 257. 257, same book, 16th Ham Jurisprudence. The actual existence of a statute prior to determination that it is unconstitutional is an operative fact and may have consequences which cannot justify being ignored. When a statute which has been in effect for some time is declared unconstitutional, questions of rights claimed to have become vested, of status, of prior determinations deemed to have finality and acted upon accordingly, of prior determinations deemed to have finality and acted upon accordingly, and of public policy in the light of the nature both of the statute and of its previous application, demand examination. All right? It has been said that an all-inclusive statement of the principle of absolute retroactive invalidity cannot be justified. Obviously, it would be ex post facto. An unconstitutional statute is not necessarily a nullity. It may have indeterminate consequences binding upon the people. All right? So you have to pay attention to what's going on. Now, let's get a few more and we're out of here. Section 258. I'm just going to read the important section here. On the other hand, it is clear that Congress cannot, by authorization or ratification, give the slightest effect to a state law or constitution which is in conflict with the Constitution of the United States. It would be what? A nullity. Why? Because it's in conflict or repugnancy. It'd be in violation of Marbury versus Madison, all right? Now, are you starting to see the gist of what's going on here? There's just one more, I think, and we're out of here. All right, Section 260 of the same 16th Ham Jurisprudence. Now, folks, head down to the law library. The books are usually green or red in color. They're kind of thick. Ask the librarian where Am Jurisprudence Second is stored. Go on over there, grab the 16th volume, start at Section 1, and just start paging through to Section 300. I'm telling you, you won't believe it. We're going to look at Section 260. Although it is manifest that an unconstitutional provision in the statute is not cured because included in the same act with valid provisions, and that there are no degrees of constitutionality. In other words, it's either constitutional or it's unconstitutional. There's nothing like, it's kind of like half pregnant. There's no such thing, all right? So that an act is either constitutional or it is unconstitutional, okay? So if you got statute here and most of it's constitutional and a part of it's unconstitutional, guess what? It's all unconstitutional. So what we got here is a crime bill. And we got part of it is constitutional and part of it's unconstitutional. Obviously, they had no authority under the Second Amendment to fool around with the right of the people to keep and bear arms. They couldn't demand that the people not possess certain firearms. So this directly applies to this crime bill. Obviously, part of the bill is constitutional and the other part is not constitutional. So what is the end result? The whole bill is unconstitutional. Does everybody see that? Now, I want you to start looking at these things, and I want you to start hammering these guys, and don't let these guys pull this kind of stuff. Hook them. Over there and collar him, say, hey, Charlie, why don't you step over here for a minute? I want to check out something here. I mean, you would if they had your wallet, wouldn't you? Does that make sense to you? Now, we're going to get into a unique argument here. For the last half hour, I've been trying to hammer home the power of this book. This book right here. Okay? I'm trying to hammer home the power of this book to teach you that this is the most valuable book in your whole life. If you know what's in this book, I am telling you, you are in full possession of your American citizenship. If you don't know what's in this book, I am telling you, you're going to be a slave, subject to the whim of extrajudicial people who want to tell you what to do, when to do it, how to do it, and how high to pack it. Now, my honest philosophy to you is, as a kindness and a Christian to you, I tell you, learn this book. I love it when these guys tell me I don't have any rights. I said, well, if you believe that, let's go to court. And on the end of the day, we'll see who owns who. But I'm going to tell you right now, if you violate any of my constitutional rights, I will sue your socks off and I will attach everything you own, bank, business, and home. And I'm telling you, I'm the one your mama warned you about. So you damn well better listen. Do not violate my rights, because I will come after you, and I will take care of business, and I will do what is necessary and proper, and I will pull every stop out, and I will go dig up every nut, bolt, and screw. And when it's done, you will find out you mess with the wrong American, because this American is not going to back down. Okay? Now, we're going to get into a real special argument. Now, this argument has taken almost 18 and a half years to develop, so I want you to pay attention here. This argument is a unique concept that has been honed like a razor to a very meticulous edge so that you can understand what's going on. Obviously, we have established clearly that you have a constitutional right. And obviously, we have established that you are the beneficiary of the contract. And we have established that the Constitution is a contract in writing enforceable in the court of law. And we have established that you have a right to claim specific performance on the contract. And we have established that it's supposed to be interpreted in your favor. So if you got an honest constitutional belief, they have to listen. Now let's take that to the next step. The next step is, can a state arbitrarily and erroneously convert your right into a privilege and issue a license and a fee for it? Let's start with here. We're going to start walking down this sheet. Okay? Murdoch versus Pennsylvania, U.S. Supreme Court. Now, when you want to go into the law library and you want to look up something, what you want to do is understand that Supreme Court is Trump. Okay? That's the clearest way I can explain it to you. If you got a Supreme Court case, that trumps a district court, that trumps a court of appeals, that trumps a state court, That trumps everything. So you want to deal with Supreme Court cases as best you can. Murdoch versus Pennsylvania is a unique case. It's recorded at 319 U.S. 105. That's the 319th volume of United States Supreme Court Reports on page 105. So when you go to the law library, go into U.S. Reports, ask the little gal there, or the little guy that's behind the counter, where is the United States Supreme Court Reports? They'll tell you right where it is. You grab volume 319, you turn to page 105, and it'll give you the case of Murdoch versus Pennsylvania. Murdoch versus Pennsylvania is a real unique case. And I'm telling you to read the case. You get the case. The judge always likes to see that you're ready. And I'm going to summate basically the case briefly. Basically, it is a religious test case wherein Jehovah's Witnesses in the year of 1943 wanted their right to be able to go and preach among the public, because that is their right to evangelize, okay? In Pennsylvania, they wanted them to have a license to solicit, okay? This is basically the crux of the case. Now, what happened was the Jehovah's Witnesses claimed their First Amendment right of life, liberty, and pursuit of happiness, the right to worship and exercise their religion unencumbered, right? And, of course, that's one of the mainstays that founded this country, was the religious freedom, okay? And basically the points on the case that are established are: a state may not impose a charge for the enjoyment of a right granted by the federal Constitution, and that a flat license tax here involved restrains in advance the constitutional liberties of press and religion and inevitably tends to suppress their existence. All right, let's pull that over there. Everybody see that? Okay. All right, I'll start again. A state may not impose a charge for the enjoyment of a right granted by the federal Constitution, and that a flat license tax here involved restrains in advance the constitutional liberties of the press and religion and inevitably tends to suppress the exercise thereof. That the ordinance is non-discriminatory and that it applies also to peddlers of wares and merchandise is immaterial. The liberties granted by the First Amendment are and in a preferred position. Since the privilege in question is guaranteed by the federal Constitution and exists independently of the state's authority, the inquiry as to whether the state has given something for which it cannot ask a return is irrelevant. All right? No state may convert a secured liberty into a privilege and issue a license and a fee for it. Now, a lot of people come back to me and say, well, I'm not a Jehovah's Witness, so that case doesn't apply to me. I want you to reach. I want you to understand, we're not talking about whether you're a Jehovah's Witness here. What we're talking about here is, are you an American and do you have rights? What they are talking about here is that these Jehovah's Witness people exercise their rights timely, that they had a right to worship and exercise and worship their God and evangelize as they chose, and that the state came in and arbitrarily converted that right into a privilege and issued a license and a fee for it. That is totally unconstitutional. Now, we took that case as a pioneering case, and we argued that case for all of your constitutional rights. All you need to do is keep in mind that you are an American and you have constitutional rights, number one. Number two, you have to keep in mind what right. Can you pull a right out of the Constitution? If you can pull a right out of the Constitution, and I'll give you an example. How about the right to travel freely and unencumbered, pursuant to Schreiber versus Thompson? I won't get into that. How about the right to keep and bear arms, right? Does the state have a right to require a license and a fee for the exercise of the right? And if they do, can you ignore the license and the fee? We'll get into that. Now, obviously, in this case, it's clearly established, and this is the premise of this case: no state may convert a secured liberty into a privilege, issue a license and a fee for it, and require you to have that. Otherwise, you committed a crime. That's totally 100% unconstitutional. I want that to get across real clear. Now let's jump to the next case. By the way, Murdoch is recorded at 319. That's the 319 volume. U.S. Reports, page 105. We'll start the case. All right? Go read the case, though. Make sure you read the case. I don't want anybody to come up and tell me they didn't read the case, because I'm going to get on you. You're not following. That's failure to follow instructions. Okay? Now, we're going to walk down the next step of this case. We took care of Murdoch here. Let's go to Shuttlesworth versus Birmingham, Alabama, which is recorded at volume 373. The same U.S. Reports. You go to volume 373, turn to page 262. When we go to Shuttlesworth versus Birmingham, Alabama, this is another unique religious case, okay? In this case, 6 ministers were accused of inciting to riot and otherwise create a disturbance and disturb the peace, okay? They had a sit down. This case came down in 1962. And what happened was they said they needed to have a license to have a public gathering, okay? And what happened was it went to the Supreme Court, and the Supreme Court says, no, you don't need to have a license for the exercise of a First Amendment right to freely assemble, okay? Right, basically the gist of the case is the Negro ministers were convicted in Alabama State Court of aiding and abetting in violation of criminal trespass ordinance in Birmingham, Alabama. The only evidence against them was to the effect that they had incited 10 Negro students to engage in a sit-down demonstration at a white lunch counter. Actually, there were 6 ministers, but only 2 got charged, as a protest against the racial segregation. And they cite other cases. A lot of times you can find other cases in these cases. In Gober versus City of Birmingham, Alabama, this court today holds, on the authority of Peterson versus City of Greenville, that the convictions of those 10 students for criminal trespass were constitutionally invalid. Since those convictions have been set aside, it follows that these petitioners did not incite or aid and abet any crime, and that therefore the convictions of these petitioners must be set aside. Now basically what they were claiming is their constitutional right to freely assemble. The cities was claiming that they had to have a license to put on a demonstration, which they didn't have, and they were charging them with a criminal trespass for not having a valid license to freely assemble and or protest, okay? Now, the gist of this case, I want you to see the significance of this case in view of the case we gave you before that. Murdoch versus Pennsylvania clearly established that no state could convert a secured liberty into a privilege and issue a license and a fee for it. Does everybody got that? Shuttlesworth versus Birmingham, Alabama said that if the state does convert your right into a privilege and issue a license and a fee for it, you can ignore the license and a fee and engage in the right with impunity. That means they can't punish you. They got to let you go. All right? Does everybody see that? It's very important that you understand, first, your Constitution is the supreme law of the land, and that you have that right, and that right shall not be infringed, and it's supposed to be enforced in favor of you, the clearly intended and expressly designated beneficiary. It's very important that you understand that no state may convert that right into a privilege and issue a license and a fee for it. And if they do, Shuttlesworth versus Birmingham, Alabama says you can ignore the license and engage in the right with impunity. That means they can't punish you. Now, the next case is very important, and it's very important that you see the argument. Okay? That's United States versus Bishop. That's 412, volume 412, United States Reports. This is page 346. We come down here. United States versus Bishop is a very unique case. Basically, what Bishop does is it sets a standard for what constitutes a criminal violation in terms of willful intent. Okay? Willfulness is one of the major elements that is required to be proven. In any criminal element, you have to prove, 1, that you're the party, 2, that you had a method or an opportunity to do the thing, and 3rd, that you did so with a willful intent. Now, when we get to willful intent, willful is defined as an evil motive or intent to avoid a known duty or task under the law with a moral certainty. Obviously, in the previous 2 cases, you have decided that you have relied on the United States Constitution. And you have relied on decisions of the United States Supreme Court. So could you have willfully done any deed or crime? Obviously not. So guess what? This case stipulates that you have a perfect defense to the element of willfulness. Alright? Since the burden on the prosecution is to prove that you did willfully and knowingly avoid a known duty or task under the law with a moral certainty, he cannot perform that task, can he? Because it's obviously you have a constitutional immunity to that. The previous case, Shuttlesworth versus Birmingham, Alabama, said they couldn't even punish you. The case before that said you didn't need a license for the exercise of a right. And the case before that said your constitutional right is supreme over any state law. So if they pass the law in violation of your Constitution, the Constitution overwhelms the state law. So the law doesn't even exist in law. Does everybody see that? Now, since the prosecutor does not have a cause of action for which relief can be granted, Your Honor, may it please the court, counsel is specifically precluded from performing his major task. Therefore, Your Honor, may it please the court, at this time I would motion most graciously for a dismissal with prejudice for failure to state a cause of action for which relief may be granted by this honorable court, and I'd kind of like to collect my costs and fees for having to defend this patently frivolous and spurious complaint, sir. May it please the court. Laughter will usually break out thereafter, at which point the judge will usually turn to the prosecutor and say, "Well, Mr. Prose, what do you think we ought to do about this young fella?" And he'll say, "I'd go for the motion to dismiss, Your Honor," and the judge will turn to him and say, "That's a good answer, because I don't think you're ready for this kid today." And 40 attorneys will break out laughing. Okay, that's actually happened to me, folks. I'm telling you, this argument is a killer argument. It's good for every single constitutional right you've got. All you have to do is fill in the blanks. What constitutional right? Prove that you have the constitutional right. Tell them the state doesn't have a right to convert that right into a privilege. Tell them that they can't even punish you if they do. And then claim that the prosecutor can't prove willfulness, so you obviously didn't do no crime, and then flip around and demand for your dismissal, which is your right, and get your costs and fees for having to defend this frivolous case. May it please the court. And I promise you, you will be amazed. 40 attorneys will jump up and say, "Yeah." They'll come up and shake your hand and tell you that's one of the most magnificent arguments they've ever heard. They'll tell you you got something like King Kong for taking on the Bar Association or whatever. Now, I'm telling you these things that personally happened to me. I can relate the exact cases. That goes for practicing law without a license. Obviously, you got a right to work. You got a right to contract your right to work as you see fit, not as some arbitrary and capricious Bar Association sees fit. Right? Doesn't that make sense to you? You don't want to belong to the union, that's your right. This is a right to work state, right? The bottom line is this: they cannot compel you to have a license or pay a fee for the exercise of your right. And if they do, you can ignore the license and a fee and engage in the right with impunity. That means they can't punish you. And since you got a perfect defense to the element of willfulness, they cannot punish you. They have to dismiss. They do not have a cause of action. They have to dismiss. They do not have a cause of action. Now, this argument I'm telling you has taken us over 18 years to develop in the courts and in law libraries over the years, and just kind of compiling and arguing cases and doing this. This argument is a killer argument. Have they ever won against us on this argument? Nor could they in the United States of America as long as the Constitution stands. I'm asking that you pay attention to this argument and start utilizing it. We'll show you some of the techniques later in the second half, all right? Now, the word willfully has the same meaning, all right? In controlling the voluntary, intentional violation of a known legal duty. And the distinction between the statute is found in the additional misconduct that is essential to the violation of the felony provision. If they can't prove willfulness, they can't prove nada. Okay? Has everybody got that? Now, let's go to the next one. Now that you've won and your rights have been violated, the next thing they will claim, well, we acted in good faith, or well, we acted in good faith. We had good faith reliance that you broke the law. Okay? And that means you can't sue us. That's a lie. You see, since these two cases, Owen versus City of Independence, which is recorded at 100 volume, and you want to look at Supreme Court reports. Now, that's a different reporter. Supreme Court reports will actually say on the back of the reporter, Supreme Court reports. It won't say U.S., it'll say Supreme Court reports. So that's a different volume. It's a newer reporter. So you want the 100th volume, and you want to look up Supreme Court reports, and you want to turn to page 1398. There is also a counterpart case to this Owen case, which is Maine versus Thibodeau. I'll give you the site for those. Okay, I gave you Owen versus City of Independence, so I'll give you Maine versus Thibodeau. Maine versus Thibodeau is recorded at 100 Supreme Court. That's 100th volume. Supreme Court Reports, page 2502. Now, basically, the summation of what these basic arguments say. Where plain language of a statute supported by consistent judicial interpretation is strong, it is not necessary to look beyond the words of the statute, right? Now, these are both civil rights cases. The right of action created by statute relating to deprivation under color of law, of state law, of a right secured by the Constitution and the laws of the United States encompasses claims which are based solely on statutory violations of federal law and apply to the claim that claimants had been deprived of their rights in some capacity to which they were entitled. Now, whenever this happens, folks, you must understand something. And that goes for both Maine versus Thibodeau and Owen versus City of Independence. And I'll tell you the brief synopsis on both these cases. Owen was a police chief in a town of Independence, Missouri, and he got in a gripe with the city council, and they indiscriminately fired him without just cause. Owen turned around and sued. They claimed that they acted in good faith. The Supreme Court said, "Sir, you are deemed to be officers of the law. You are to advise us to the law. You can hardly claim that you acted in good faith for a willful deprivation of the law, and you certainly can't claim ignorance of the law, because a citizen out here on the street can't claim ignorance of the law, and it makes the law look stupid if an officer of the court or some officer of government doesn't know the law, and then they go ahead and abuse somebody's constitutional right." So in matters of constitutional rights, both these cases uphold one point. And the point they uphold is that whenever they violate your constitutional rights, they do so at their own peril. And it even says that in Title 18 United States Code Section 241 and 242. It says that upon conviction, you are subject to a $10,000 fine, 10 years in jail, or both, and if death results, life in prison. They're telling you, don't violate somebody's rights. Please, don't do that. Title 42 United States Code Sections 1983, 1985, and 1986 clearly establish your right to sue anybody that does that. Now, they're going to claim you can't sue them because they have judicial immunity. Well, guess what? These two cases remove judicial immunity. There is no judicial immunity for violating somebody's constitutional right. Judge, you are deemed to know the law and sworn to uphold it. You can hardly claim that you act in good faith for willful deprivation of the law, and you certainly can't plead ignorance of the law. For that, it'd make the law look stupid for a knowledgeable judge to claim ignorance of the law when a citizen on the street can't claim ignorance of the law. Therefore, there is no judicial immunity. I want to get that across. I don't know how many attorneys come up to me all the time and tell me, well, they're immune because they acted in good faith. They're just not reading their court. They're not reading their court reports, because if they were reading their court reports, they would have known this case has been on the books since 1982. Both these cases came down in 1982. So I want you to pay attention to these cases. When somebody tells you they can violate your rights with impunity, you just kind of smile and say, make my day. Okay?
If you've really listened to this, this is very, very powerful. Judges have to follow the Constitution. If they don't know the Constitution, there's a huge penalty for that. For officers to write you a ticket, traffic ticket is unconstitutional. It states that. He's actually showing you how to go in there and argue your case with that little book. So read that book and know the Constitution and know how to apply it. And when they don't know the Constitution, they're going to be in trouble. He also shows how there's 40 lawyers in the room, and when he actually went to court, and they're all laughing because they don't know the Constitution. It's ridiculous. Sit down and read this stuff, what he's saying. I'm going to, and learn the Constitution and how to apply it. If it's not constitutional, it's in void. It's not there. Any state, just like mandates of the mask. You know, when they told you had to wear a mask, unconstitutional. And anybody tells you otherwise, or if you get arrested or whatever for it, they're going to be hugely in trouble. You know, how many times have people been told you have to get a permit to do this or that? They cannot fringe on your constitutional rights. They can't do it. I even heard in my own town they were going to start a permit to have picnics at the park that our tax money has paid for. That is ludicrous. That shows you that the council and everybody doesn't know the Constitution. And that is a big lawsuit. So, hey, this is part 2. And I can't wait for the next part, but watch this video, learn what to do, and read the Constitution. Read. And you will walk through this world with so many rights, you won't believe it. Hey, subscribe. Love you guys. Give me a thumbs up. And we'll be seeing you next time.